Okay, so the case that we have today is MacPherson versus Buick Motor Company, and it's a case decided in 1916 by Court of Appeals of the State of New York, which is like the highest court in New York. It's like Supreme Court we have in India. So this case was decided by Court of Appeals of State of New York. Now, what is this case all about? As you can see, this vehicle, it is the defendant, Buick Motor Company, who was a company or manufacturer of automobiles. They were into manufacturing of automobiles. It sold an automobile to a retail dealer. So manufacturers would have dealers to whom they will sell, and from dealers, customers will buy vehicles or most of the other things that we see. Same happened here. Buick Motor Company was a manufacturer. They sold an automobile to a retail dealer, and the retail dealer resold it to the plaintiff, MacPherson, who is plaintiff of this case. So plaintiff is the purchaser, the customer, and defendant is the manufacturer of automobiles. While the plaintiff was in the car, it suddenly collapsed and he was thrown out and injured. Basically what happened, right? These are the wheels that we see in a vehicle and spoke. Okay, so this basically these parts, it just it collapsed and it just separated. It all broke down into tiny pieces basically. Okay, and one of the wheels was made of defective wood. That was the reason. So these wheels are made of woods, and because one of those wheels was made of defective wood, it just broke down into tiny pieces. As a result, the plaintiff sustained injury because he was thrown out of the car. And there is evidence, however, that the defects could have been discovered by reasonable inspection, and that inspection was omitted. So these defects were such that if you would have seen it properly, if you would have done the proper inspection, you would have come to know about it. But then the manufacturer failed to do that necessary inspection. There is no claim that the defendant knew of the defect and willfully concealed it. It's not like Buick Motor Company knew that these wheels are made of defective wood. Even after that they sold it, they were not aware. But if they would have taken proper steps, they would have done the inspection, they would have come to know about it. It was such kind of a defect. So Buick was one of the best-selling cars of 1908, around that period. And it was having 22 horsepower, 50 miles per hour. And this was sold for $900. And it was having this wooden wheels. MacPherson bought this car from a dealer who had directly brought it from the manufacturer, Buick Motor Company. The day when this accident took place, where he was thrown out of the car, MacPherson was driving it at 8 miles per hour, as in he was driving within the prescribed features that they had mentioned, like the manufacturer had mentioned, and the accident still took place. It was found that the wheel broke into pieces as it was made of defective wood. That was the main reason. Now, the company, Buick Motor Company, they had purchased the wheels from one of its suppliers who was a reputed supplier, and from them they had purchased the wheel. But inspection from the part of company before selling it to the dealer was omitted. So they said that we bought it from a supplier from whom we buy and who is a reputed supplier also. So they omitted this part. And as a result, MacPherson suffered injury and he filed a case against the company for the tort of negligence. Initially, the case was filed before a New York State Court, which is like the lower level court. Their case was dismissed. Court did not entertain the matter. After that, the person, MacPherson, he filed an appeal in New York Appellate Division and he won the case. Basically, what court said is that the defendant was not free from his duty to do the necessary inspections just because he bought the wheels from a reputed manufacturer, or because he bought it from a regular supplier. It was not merely a dealer in automobiles, right? The company, Buick Motors, it was manufacturer of automobiles. So when they are manufacturer, they are giving the final product to customers. They have a responsibility to inspect that everything is fine. It was not at liberty to put the finished product on market without subjecting the component parts to ordinary and simple tests. Many tests also would be done. If they have omitted it, that is their negligence. The obligation to inspect must vary with the nature of the thing to be inspected. What inspections you would do, to what extent you would do, that varies from the goods, right? That varies from what are you inspecting. It differs. The more probable the danger, the greater the need of caution. So when you know that, okay, it's a vehicle or it is some kind of an item that if you are using it, the risk would be higher, right? As compared to might be like a nail paint. Obviously, a vehicle, the risk is higher. So higher the danger is, higher the exposure is, there is more need to ensure that it is like safe for the customers, because you are manufacturer, you are giving the end product. So finally, court held that Buick Motor Company was liable because it had a duty of inspection and it failed in its duty. And also it was established, right, that with some necessary inspection, reasonable inspection, it could have foreseen the danger. So in such cases, it was held liable, that they are liable because they failed or they omitted to do this necessary inspection. So that's about this case, a very famous case relating to the tort of negligence.